Good afternoon, everyone. This is Mike with PricePlow.com, and I have a very special feature here today. With me is IP attorney Nick Gingo, a man who I've known since we were 18 years old, actually. And we are going to talk about the bodybuilding.com versus Jim Stoppani lawsuit that's been going on, where GNC later got added in. And so the last video I created was in my kitchen, where I was talking about the case, and I was kind of doing a little bit of armchair patent attorney kind of stuff, where we talked about, hey, if GNC does get pulled into this lawsuit, it's going to be very big. And that indeed did happen. At that point, I figured it was time to actually bring in someone who specializes in this. And Nick here can introduce himself and everything, but he really pulled up some amazing information out of this case that we didn't find. And so we're going to discuss that and talk about where we see the bodybuilding.com versus Jim Stoppani case heading, and why certain things are happening, and how maybe this could have been prevented. So Nick, welcome to the PricePlow YouTube channel. Thank you so much for joining us.
Thanks for having me, Mike.
Yeah, so can you first off give us a little bit of background about yourself, your law firm, all that stuff, and what you do kind of on a more day-to-day, week-to-week kind of basis?
Sure. I'm an IP attorney, like you said, intellectual property. I practice at a IP boutique firm in good old Cleveland, Ohio.
Awesome.
Been here since I graduated law school, so 7-8 years now.
Mm-hmm.
My practice focuses mostly nowadays on trademarks, some design patents. I also do utility patent prosecution in the material science area, but that's a pretty small part of what I do.
Mm-hmm.
The vast majority is trademarks, which is why this stuff's particularly interesting to me. My firm as a whole does mostly utility patent prosecution. But we do have a litigation group, which is also something that I did quite a bit when I first graduated from law school. About 5 years, I did pretty much straight up patent and trademark litigation. So I think that background, given that and the fact that I do a lot of trademark work now, it makes this stuff pretty interesting. So
Right, and it also seemed like there could actually be damages tied to things, which it doesn't seem like this is normal for an IP kind of trademark infringement kind of case. So
yeah, damages are generally a lot bigger deal in patent cases.
Mm-hmm. Right.
But for trademarks, usually the parties are looking for an injunction just to get the other side to stop. Generally, it's pretty clear that somebody's either trying to trade off somebody else's mark with a slightly different mark, or straight up ripping them off. Mm-hmm. Here, the parties know each other, I think, is probably a reason why damages are more of an issue. The intent, that type of stuff, really allows parties to try and multiply their damages, which makes it worthwhile to try and prove damages. Gotcha. Trademark damages are hard to show. You have to hire experts. There's a lot of discovery into sales and things like that. But when it's worth it, parties will go after it. So.
Right, and as we saw and so I'm going to stop right here. Everything we talked to, all the PDFs we're going to reference are going to be on a blog post that I'll link to in this YouTube video. And so make sure you check those, because there's a few different PDFs we're going to discuss, including the development agreement that Nick found. And so this is all publicly available information. So obviously, we've already posted some of the sales numbers and everything, and they made almost $95 million in revenue over the course of 3 years. So, and the Jim brand, be whatever we want to call the Jim brand, because it's currently being sold at 2 stores, which is very, unheard of almost. It's still selling well. So there is clearly a lot of monetary distress kind of going on. And so that's why this has been such a hot thing here.
Yeah, and the other thing that's floating around here, at least from a legal perspective, is that there's been a bunch of cases lately trademark cases where parties were able to collect damages based on the cost of corrective advertising, which can actually get pretty high.
What do you mean by corrective advertising?
So a party that is found to have had their trademark infringed can force the other side to pay for the cost of advertising to fix the market, basically, to make people realize that, in fact, they are the true owner of the mark. So whoever wins here, be it Stoppani, PhD, or bodybuilding, could potentially force the other side to pay the cost of making everyone understand who actually owns this stuff. It hasn't been pled. I'm actually kind of surprised it's not in the pleadings as a potential damages remedy, but it could still come into play.
Right. It seems like, yeah, the cases are kind of being updated over time, like just how
Yeah,
bodybuilding added GNC to the case
right.
for damages exceeding 100 million. So,
Yeah, yeah.
no,
There's a lot of lawyering going on right now. That's for sure.
gotcha. And so, yeah, so looking through the history, is it more lawyering than normal that you see here? Is this a pretty
No,
active
this
case?
looks about right. I
Okay.
mean, I think you can kind of, or well, I guess I can kind of tell that it seems like it's going to focus in on this issue of ownership of the marks, but
Hmm.
there's a lot of trademarks in general are always kind of gray. There's a lot of gray area. There's federal trademarks, there's state trademarks, there's consumer confusion, false
Hmm.
advertising claims that all sound a lot like trademarks, but at the end of the day are a little bit different. And so a lot of this, I think, is just the attorneys and parties trying to flesh out all the different theories that they threw out there at the beginning of this thing. But it seems like, ownership in particular is going to end up being a very big issue here. And that's what most of the briefing's been about. There's been a motion to dismiss filed by bodybuilding with regard to Stoppani's counterclaims of trademark infringement, and that basically they're arguing about who owns these marks and kind of relatedly who has licenses to these marks. I think that's where that the joint development agreement that I pulled up and sent to you earlier.
Right. And so, yeah, we'll share that. We're going to dig into that pretty in depth here. So, can you kind of give me the bullet points of this case, kind of
Yeah,
the way you interpret it, and then we can kind of jam on these different documents and see why things are the way they are and why where it may go.
sure. Yeah. Actually, before I go too much further,
Yeah, please do.
let me give my standard disclaimer that the opinions I'm expressing in this video are my own, not those of my firm. Nothing on the video should be construed as legal advice or as creating any attorney-client relationship. As one of my mentors used to say, if it was legal advice, you'd be getting a bill.
Right.
So that's just so everybody's clear on that.
And we are not paying you either. There's
No, this
no.
is just me and you jamming. So basic facts based on what I saw in the file and kind of what I've seen in the news, including on the blog. Around 2013, Jim Stoppani and PhD Fitness were working with bodybuilding.com to come up with this gym brand. They signed a development agreement, which I'll probably refer to it as a JDA. That's short for Joint Development Agreement. Where they agreed to work on formulas, they agreed to work on the products themselves. They also agreed to work on branding, marketing stuff. So like the actual names of the products, the packaging of the products, how the packages would look, colors, things like that. Everything seemed to be going okay. According to the pleadings in early this year, 2016,
Right.
Stoppani and PhD started sending letters to bodybuilding.com disputing ownership of the marks, basically saying that they, PhD, Stoppani, own the marks and that bodybuilding.com should be prepared to stop using the marks once the agreement expired. I think there was a couple letters back and forth, and I guess probably maybe more than just letters, but eventually in June, bodybuilding actually took the step of filing for what's called a declaratory judgment. So bodybuilding.com is the plaintiff in this case, even though Stoppani and PhD are actually the alleged trademark owners here. Bodybuilding.com is asking the court to declare that they don't own, that bodybuilding owns the trademarks and that PhD Stoppani do not. Stoppani countersued for infringement, and then bodybuilding recently added, like you said, added GNC and I think some other retailers, or at least some John Doe's, which is kind of a placeholder, probably just for leverage purposes. I'm guessing that bodybuilding's lawyers probably assume that Stoppani and PhD have some sort of agreement with GNC where they'll indemnify them if they get into trouble for an IP perspective. So,
and that's typically, from what I hear, I've not seen the GNC Stoppani agreement. I assume there is one, but I have heard from many different brands who've said, yeah, typically GNC is indemnified. And so what you're saying is bodybuilding.com is adding GNC because then GNC could then put pressure on Stoppani to kind of settle or something along those lines.
On two levels, yeah. I mean, on the one, on a basic kind of business to business perspective, you've got probably have people at GNC who are annoyed at a minimum that they're involved in a lawsuit now.
Of course.
That are potentially, pressuring Stoppani PhD to do something about this. And I guess, and then on another level, adding GNC adds a whole nother level of damages to the thing, because now you've got sales by GNC to third parties, as opposed to sales from Stoppani PhD to GNC. So you've got the added markup, the added revenue, which adds to the potential damages, which is the ultimate threat that you kind of use to force settlement at a minimum. So I think there's probably it's two-pronged, really.
Gotcha, good stuff. So rewinding a little bit to when originally Stoppani sent the original letter saying, "Hey, we're going to use this trademark as ours," or whatever. Was that kind of normal? Was everything? I mean, yeah. Would you consider that to have been a normal thing that would happen there, or was it kind of like this development agreement was kind of vague about it? So maybe that was why.
Yeah, I think. I mean, typically a joint development agreement that's limited in time, like this one was. I mean, this one said it was going to end, I think, in 3 years with maybe 1 year, another additional year optional. But it was pretty vague as to who would own what at the end of that 3 or 4 year period. And I think because it was so vague, Stoppani or PhD were kind of in a position where they had to stake a claim. Somebody had to stake a claim here because there's a lot of money involved. These products are selling well.
Right.
Once this thing ends, it's kind of the Wild West. I mean,
yeah.
Maybe the hope was you get some sort of agreement from bodybuilding.com, like a continued license or yeah, we'll stop. But obviously it didn't work out that way. But yeah, I think it was kind of a function of the vagueness of the JDA. They kind of had to do this. I mean, obviously they could have done it in a different way. I don't know, Right. I know we tend to not send letters if we don't have to. It's usually more phone calls. And I'm sure maybe there were phone calls too. I think eventually if those didn't work out, then you send the letters more to everything.
Gotcha. Okay, so that's kind of where we are now. I guess are there any other facts of the case you wanted to mention? Any other kind of bullet points?
I mean, nothing really. I mean, I think, like I said earlier, I think the key issue is going to be ownership of these marks. I mean, I think that's what sparked it in the first place. I think that's why Stoppani and PhD sent the letters. I think that's why bodybuilding put their foot down and filed the declaratory judgment, the DJ.
So can you tell me in your words, like what defines ownership of a mark then, like in America, or maybe you might only be able to speak to Ohio in this, but I think that's more of a federal thing.
I can speak to federal trademark law. I mean, there are state trademark laws too. They generally look similar. At least with respect to federal trademarks, ownership of the mark is goes to the person who uses the mark. It's not like a patent where you have an inventor necessarily. I guess at its most basic, a trademark is a source identifier for goods. It can be a word. It could be product packaging, like the way the product looks, and you can see that in some of these pleadings. That's part of the argument. It isn't just JYM. They're arguing about the diamond plate look, I think, and some colors. All those things separately can be trademarks. But ownership really vests in using the mark in commerce, so in interstate commerce. So in association with goods being offered for sale or services, but in this case it's goods. So it's really who was using the mark on products being sold to consumers first. And that's kind of the generic common law way you determine ownership. I mean, the reality is if you look at the agreement, it seems fairly clear that the parties agreed that Stoppani and PhD actually do own the IP.
Right. So that's kind of like the big reveal that we're teaching here, because everyone's been saying, myself included, hey, America is a first to use kind of country, correct? And so it seems like bodybuilding.com was first to use this, first to put it in commerce. It seems like they were the ones who, published the webpage and paid for the design, came up with the design, possibly if, everything is true. But you're saying that this agreement, though, like where exactly, I don't know if you have it open or whatever, but like where could we like see in the agreement where you're starting to think that there's hints that Stoppani might own it?
Yeah, I mean, if you look at the agreement, well, so I guess to take a step back,
Okay.
first to use, you're right about first to use. Use is the key, but use on behalf of a third party can use a mark on behalf of the trademark owner. I mean, you could have a little, Joe Blow plumber guy who comes up with a trademark and files for it and licenses it to a company to use for sale with products. And in that license, they agree that everything's the language is inure to his benefit. So he's still considered the owner. He's not using it. This other company's using it on his behalf. And that's kind of what you have here. I mean, I'm looking at section 3.3 talks about packaging. Bodybuilding.com's developing this packaging. Final approval will be their sole responsibility. They may use the trade names. Company, which is PhD Stoppani, grants bodybuilding.com the exclusive right and consent to use the trademarks. On the other hand, I think it's section 11. And this is kind of the issue. We talked about this a little bit before. There's lots of sections of this agreement that talk about IP in different ways and don't do a great job of defining it, which is why they're in court, frankly.
Right. So normally, if you being the best IP attorney on the planet, if you had written this kind of JDA, you would have stated, here's the owner of this IP, or here, like
you'd want to be really clear, certainly more clear than this about what is the IP. I mean, what are the marks? And I mean, and you use the standard language about, this word mark, this design, really define those things as much as you can. Talk about what the IP is, what the marks are, and then be very clear on who owns the marks, who's being licensed to use the marks, how they're being licensed. Is it exclusive, non-exclusive, how long, in time, where, in geographic scope, and then again when it ends. I mean, I think that's part of the issue is, and we'll talk about it a little more. Some of these clauses are said to end with the agreement. Some of these clauses are said to not end with the agreement. Some of the clauses. And some of those, some that end and some that don't, both deal with IP. So it's kind of unclear as to which ones still fly. And it actually ends up falling back on contract law, which is not where you want to be, because contract law is old as the hills and really gray. So, I mean, you could be a lot more clear. I found that, by the way, Section 8 actually talks about IP. The heading is IP, intellectual property.
Yeah, so I'm on page. So for the viewers following along, if you have the PDF open, it is the PDF page 4. But on the top it says page 5 of 17. But anyway, you're looking for point 8 intellectual property underlined, right?
Right.
Okay.
And and even this is kind of sketchy. 8.1 says bodybuilding.com shall own and have all rights of ownership to labels and advertising materials for products. That's bodybuilding.com's intellectual property. Company and Stoppani retain IP rights as to formulas for products. Company, Stoppani, and bodybuilding shall jointly own formulas they jointly develop. So that it's kind of parsing out, the different ownerships. Then 8.2 talks, and this is kind of the crux of, I think, the argument is 8.2 says, company, that's PhD, company shall own and have all rights of ownership to trademarks and trade names provided by company for use with products. Company grants bodybuilding.com a royalty-free worldwide right to use company's intellectual property for products. And if you look later in the agreement at section 20, that specifically says that amongst other sections, section 8 shall survive termination or expiration of the agreement. So arguably, and this is bodybuilding.com's argument is, look, whether or not bodybuilding.com owns this, at a minimum, it seems like they're licensed to use these trademarks, and that license is royalty-free, so it's free. They don't have to pay Stoppani anything. It's worldwide, and it's perpetual. I mean, it didn't end with the development agreement. Now, that's that's crazy. I mean, that's a
Really?
license. I mean,
Yeah.
that's not typical. And frankly, that's Stoppani's counter argument, is that it's not, that can't be the way this thing works, because that would be ridiculous. Why would anybody sign a JDA that says that once it's over, the other party gets to use the trademarks forever, everywhere, for free?
I get you. Okay, so now getting back to 8.1, the
Yeah.
company agrees to assist. Where is it at?
Agrees to assist. You're talking
No,
about the
okay.
section.
Well, I was looking at one part where company shall. Okay, maybe it's 8.2. Companies shall own and have all rights of ownership to trademarks and trade names provided by company, which is PhD, for use of the products. The brand Jim itself never fully got trademarked though. Like he later on trademarked Jim Supplement Science. So is it possible that 8.2 doesn't mean anything because there was no trademark to control out of 8.2? Does that make any sense?
That makes sense. I guess the thing to focus on would be that trademark. So you don't trademark. Trademarking is kind of a misnomer. There's a registration. You can register a trademark at the U.S. Patent and Trademark Office, and you can get a federal trademark registration. But a trademark can actually exist completely separately from the existence of a federal trademark registration. And this gets back to what we talked about earlier. A trademark actually comes into existence as soon as you start using it as a trademark. I mean, if I walk out tomorrow and sell a hat or a candy bar with some name on it, that I now have a trademark in that mark. I have trademark rights, and so this section 8.2 is actually vague enough that arguably it's covering federal trademark registrations, but also marks that are just have arisen through common law, through just use. So that I think that first sentence of 8.2 makes it pretty clear that ownership stays with PhD. Now, the one thing that I just noticed actually is that it does talk about all rights of ownership to trademarks and trade names provided by company.
Right.
Interesting, because this whole thing
did he provide it?
Development agreement. I mean, what about things that were developed jointly between the two parties? I mean, so maybe Jim JYM came from PhD, but maybe the look of the packaging came from bodybuilding.
Which seems like they did the original design work per the affidavits, if they're true.
Which would mean that maybe that doesn't fall under 8.2, which is the royalty-free worldwide right section. So that's another. I think that's going to be, and I think that's an argument that Stoppani makes in his motion, or in his response. So what happened was, bodybuilding.com filed. Stoppani answered, and in his answer, he asserted a counterclaim of trademark infringement, amongst other things. At that point, bodybuilding.com filed a motion to dismiss that counterclaim. And in the motion to dismiss the counterclaim was when bodybuilding.com pointed to this JDA and said, no, this counterclaim of trademark infringement is ridiculous. We own it, but even if we don't own it, at a minimum, we're licensed to it, and so we can't be infringing a trademark that we have a license to.
I see.
And so that's where this thing came up, and then Stoppani has actually filed a response to that motion, and in that response, he's made a couple arguments. One is that kind of absurd result argument that we talked about earlier, that essentially, look, this is basic contract law. You got to look at the agreement as a whole. And if you look at it as a whole, you wouldn't interpret it to be so one-sided. Of course, it'd be ridiculous for somebody to agree to something like that. So it can't be that way. And then but another argument that he made was that 8.2 talks about trademarks and trade names provided by the company, and that maybe some of these things weren't provided by the company and therefore don't fall under 8.2 and may not be subject to this perpetual worldwide license that bodybuilding is pointing out.
Wow. Okay, so if this, Do you, if this were to go to court, and I would like to maybe get your opinion if you think this will settle or not, or maybe you just don't know the parties enough to answer that. But if this were to go to court, it seems like bullet point or the Section 8 intellectual property is going to be greatly discussed in court. Is that true?
Yeah,
Like,
I would think. I mean, that seems like it's probably the key. I mean, 8.2 in combination with 20 certainly seems bad for Stoppani PhD.
you think it seems bad for Stoppani and PhD?
Yes.
Okay.
Because I think kind of first blush read, it certainly seems like they own this stuff, but they granted this massive license to bodybuilding. And so at that point, even if they own it, it's kind of a hollow win. I mean, yeah, you own it, but you can't stop them from, Stoppani PhD can't stop bodybuilding from using it.
I gotcha.
That's the decision.
But okay, and if that were the decision, does that mean GNC can still use it then? And then we have this dual brand, dual store kind of thing going on.
Yeah. So the other, maybe not necessarily. And here's why.
It's a mess, isn't it?
This is insane. Because 8.2 says that it's a royalty-free worldwide right to use, but it doesn't say anything about whether or not it's an exclusive right to use. There's another section of this thing, and I wrote down, I think it's 3.3. If you go up to section 3.3.
Okay, yeah, back up to page
3.3, which talks about packaging. It says, in the second to last sentence, it says company, PhD, grants bodybuilding.com the exclusive right and consent to use the trademarks provided by company or co-developed with bodybuilding.com, subject to the terms of this agreement.
Is that surviving?
No.
Okay.
Yeah. So if you go back to section 20, section 3 is not one of the surviving sections of the agreement. So I think maybe Stoppani's best argument would be no, everything we're talking about here doesn't fall under 8.2, it falls under 3.3. It was exclusive while this thing was in existence, but that's gone now. And if it's completely gone, now all of a sudden we're back to Stoppani owns this stuff. Bodybuilding's completely out of luck. At a minimum, I think the argument, if 8.2 said exclusive, then I think bodybuilding that'd be the best case for bodybuilding. I think they'd be able to argue, not only do we have the right to use this thing for free around the world, it's exclusive. And there's some case law and argument to be made that it's exclusive even with respect to Stoppani and PhD. Like, they can't even use it.
Really?
So literally, you own it, and that's it. You can't use it. You can collect royalties on it normally, although in this case you couldn't. So but the fact that it isn't in there, but it is in 3.3, again, like general contract law 101, if they put it in one place and didn't put it in another place, they meant to not put it in the other place. And so it's really not supposed to be exclusive, in which case you could have a situation where you could have dual companies selling the same brand.
Wow. Okay. So let's say this did go to court. You've like litigated cases, not like this, but you've litigated cases actually in court in front of a judge and everything, right?
Yes.
So like, how long would we spend arguing about this? If I was Stoppani's lawyer and you were bodybuilding.com's lawyer, like how does it work in court? Is it like the TV shows? And kind of give me a little.
No, it's not. And I mean, I guess the first response is, and you mentioned this before, is would it even go to court? I mean, truthfully, this will probably settle. I mean, I even though the amounts of money that are being thrown around as potential damages are high, I mean, to prove those types of damages, I mean, you're looking at attorney's fees of maybe $1 million.
Oh wow, okay.
It could get expensive. And this is a big case. Like, there's a lot of, if you look at the pleadings, there's a lot of like ancillary claims, or it isn't just a straight up trademark infringement done. I mean, there's a lot of secondary claims. I think there's going to be a lot of facts. There's potentially going to be a lot of depositions of witnesses, and those witnesses would then probably appear at trial. I mean, could be a week. I mean, could be longer, could be shorter. I mean, but a trial on this could get ugly just because it's very fact intensive. I mean, and part of that too is, like I said before, intent. those types of arguments revolve around what people were thinking at the time. So, I mean, you're talking about, you could have Jim Stoppani on the stand for a day or two talking about the beginning of this thing and who said what and what the agreements were and why he would have agreed to something. And then you can have people from bodybuilding.com sitting there and saying the exact opposite thing. So, I mean, there's definitely a lot of issues here. It's the contract itself isn't very clear. So, I mean, you're going to have lawyers parsing through the contract potentially in front of a jury, trying to convince them that certain sections matter, certain sections don't. I mean, it could be ugly. And I think that's partly why I wouldn't be surprised. I mean, it's an easy guess for me to say that it's going to settle because like 95% of cases settle.
Right.
That's how it goes. So.
Yeah, it seems like the further this one's gotten along, it seems like there's a lot of stubborn heads involved. And I'm not just saying Stoppani. Everyone, and let's be honest, the supplement industry, which you're a little bit familiar with, I'm a lot familiar with, we're a lot of stubborn oxhead guys. And this is
and
that is the industry.
Frankly, those are the kind of cases that do go to trial. I mean, my trial experience is actually limited to patent cases.
Right. Okay.
Not actually tried a full trademark case because they've all settled. But in the patent cases, the ones that have gone to trial, I was in Arizona for 2.5 weeks at trial for almost 2 weeks. And it was because it didn't make a ton of sense monetarily. I mean, you had parties squeaking out to make money on it after attorney's fees and everything else. But they felt like they were in the right, and by God, they were going to get their day in court. So, I mean, that's, again, getting back to the fact that because this agreement is so vague, I think both parties have decent arguments as to who owns these things or who's licensed. And so that's another recipe for maybe a long, drawn-out case.
Wow. And so if it did go to court, you're saying it would be a jury trial, or would it be, how does that?
It's up to the parties. I think I don't have the complaint with me. It'll say on the complaint if the jury trial was requested. As long as one party requests it. Let me pull it up. Demand for jury.
Amended one.
Yeah, so it would be a jury trial if it got that far. I mean, there's already motions to dismiss floating around. There's a motion for preliminary injunction that Stoppani filed. So
can you explain to the readers what that means, or to the viewers?
So preliminary injunction. So there's damages. There's money damages. That's one remedy that you can get for any type of IP infringement, trademarks, copyrights, patents, and that's typically the standard kind of way to understand damages is, on the one hand, is to make the aggrieved party whole. So I own this IP, you infringed it. Had you not infringed it, I would have made X amount. Therefore, you owe me X amount. That's kind of baseline damages. You can also get things like disgorgement of profits, which is a little more punitive. That would be, I own this IP, you infringed it. In order to punish you for your infringement, you owe me all of your profits, even if it's more than the profits I might have made. That's a lot harder to get. It's generally a bigger amount of money. That's available too. But aside from damages, there's injunction. And an injunction is a court order to the infringer telling them to stop what they're doing. Right. And it has to be pretty detailed. And say you can't make, use, or sell any products that have a mark that's similar to these marks or these designs or things like that. And it would apply to that party and any related parties, things like that. And that's typically what a trademark case is about. It's about, hey, I have this mark, I need you to stop, and you stop. And that's standard. That's pretty standard.
Yeah.
This is less so. So in this case, you can have an injunction at the end of the case after liability is determined. The court as a whole, judge and jury, decide that somebody infringed. How do we fix this? Oh, an injunction. You can also have a preliminary injunction at the very beginning of the case. And that's what Stoppani, PhD, that's what they filed for here, was a preliminary injunction at the very beginning of the case, and it's basically to preserve the status quo. The argument is basically, look, we can't let this continue during the pendency of the case because I'm being damaged by the mere fact that they are continuing to do this. and I will never be able to be made fully whole for that. And so the court should stop them right now, hold everything the way it is, and then if I lose, you can remove the injunction. If I win, then all the better.
But that didn't happen.
That hasn't happened. Well, the motion's been filed, but I think it's fully briefed, but the court hasn't ruled on it yet.
Gotcha. And would that be a judge who rules on that kind of thing?
Yeah. So, and that's what I was going to say. So, yes, ultimately this could be decided by a jury, but it could also be decided by the judge much earlier. I mean, you've got motions to dismiss, which are, in this case, are directed to specific pieces of the case, like dismiss this counterclaim, but that can be dismiss the case completely. In this case, it's not. You've got motions for preliminary injunction, which is kind of like a mini. It's a good way to get a peek at what a judge wants to do sometimes, because part of the test for preliminary injunction is your likelihood of success on the merits. So you're kind of saying to the judge, look, we haven't done all of our discovery and we haven't fleshed all this stuff out, but we think we've got a good chance of winning, and so you should stop them now. And you can get kind of a little bit of a read at least, something.
Interesting.
What the judge might do in the long term. So we could get a ruling on the preliminary injunction that might go a certain way and convince the parties to settle the thing. I wouldn't be surprised if there's motions for summary judgment once all the evidence gathering is done. So at the beginning of the case, you can kind of move to stop the case based on the pleadings, just the stuff that's, the answers, counterclaims, which is all pretty bare bones stuff. There's not a ton of juicy stuff. Although actually there's more here than usual. After evidence, so after exchange of documents, after depositions, things like that, the parties can so discovery ends, and then there's a period where the parties can file these bigger motions for summary judgment that say, okay, judge, here's all the facts now and what we argued before. Now please find for us. We don't even need to go to the jury. It's obvious. It's very clear that we win here. And I mean, that's pretty standard, and I'm sure that will happen here. And you can win there too. Or you can get a ruling that is close enough to a win that, again, forces settlement. So I think there's always lots of stopping points. I think it looks like the parties are ready to brief lots of stuff. There's going to be a lot of discovery, I'm sure. So there's a lot that can happen between now and a jury trial that will still be interesting and could change the complexion quite a bit.
Gotcha. Okay, so we'll have to keep up to speed. It's like I'm almost in too deep at this point, and I can't stop updating the case. So maybe at some point we might need to have your back or whatever if things blow open or blow closed or whatever. I never really wanted this job of reporting on this, but we're in too deep, like I said. So I appreciate that, because I really didn't know all that procedural stuff. Obviously not being a lawyer like yourself. That's incredible. So if it did go to a jury trial, and a jury, would it be like black and white? Like jury says, bodybuilding.com wins, you guys can't do anything and they can do everything? Or is there like can there be a mixed kind of judgment from the jury? Like how does a jury actually decide something?
It can be. I mean, a lot would depend on what happens between now and then. I mean, some claims could fall out. I mean, parties may just dismiss certain. So in a complaint, there can be multiple claims.
Right.
I mean, there's a claim for trademark infringement, a claim for false advertising, a claim for, consumer confusion. Well, I guess not consumer confusion, but Lanham Act, unfair competition, and they all have kind of similar elements, but they're all technically different claims. Potentially, some of those could fall out during the course of the case. And depending on what's left over, that you're going to have the jury deciding each claim. But even within each claim, like we talked about, there's no good definition of what the marks are right now.
Right, back to the whole point. All right.
So back to you could have the jury ruling that Stoppani owns JYM, the word mark, and JYM, the logo, but that he doesn't own the design of the packaging. And in which case you'd have a situation where, basically bodybuilding could use the same packaging with a different word. A jury could easily split the baby, and the judge could easily split the baby on the different marks, on which marks were jointly developed versus not.
Okay.
it can get ugly.
Wow. And so split the baby, is that a lawyer lingo over there?
Yeah, yeah, that's
Nice. One other thing, you've brought up the word common law a
yeah,
bunch. So can you quickly describe like what that means in this
yeah,
context? These
yeah.
contracts and stuff.
So like I said, trademarks are kind of this weird beast where so patent law is federal.
Hmm.
There are no common law or state law patents. If you invent something and you want protection, you have to file for a US patent. You have to go through the US Patent and Trademark Office. You have to get your US patent registration, and that's what you use to sue people for patent infringement. That's the only way to do it. Trademark law is much older in a sense. It's developed for a different reason. Patents developed because they wanted to encourage people to invent things by giving them inventors limited monopoly on that invention. You know, you came up with something cool. Here's your patent. You can stop other people from doing this thing for it's 17 years or 20 years, depending on the timing.
Hmm.
Limited monopoly, and then after that, anybody can do it.
Hmm.
That's patent. Trademarks arose out of a consumer protection reasoning. It's to protect the end user so that they know that I'm buying this product. You know, I'm buying Coca-Cola. I know that I'm getting Coca-Cola
Right.
from Coca-Cola, from the company, from a certain source. And that's older than patent law. That's consumer protection concerns. That stuff's ancient. And so there's this whole body of law that arose from consumer protection, and that's why I was throwing out like unfair competition and things like that. There's this whole body of law around false identification of source that's arose from state to state, and it differs a little bit from state to state, but it ultimately addresses this issue of, hey, what you're doing is confusing to consumers, and therefore you shouldn't do it.
Hmm.
On top of that is federal trademark law, which is basically an attempt to like standardize that, so rules are more similar across the board.
Hmm.
But it's still the same concept. It's protecting consumers from being confused as to where a product came from. So you can have a common law trademark, you can have a federal trademark. You can use either one to sue someone. It's actually even more.
We just hang
You
on.
can have a federal registered trademark. You can have a federal unregistered trademark. Because you lose me? Okay.
We're breaking up a little bit.
Okay. I just quick. So you could have. It's all about use. If you use it across state lines in interstate commerce, it's called. That gives you federal rights, or starts to give you federal rights. If you don't register it, you still have some federal rights. And by that I mean you can sue people in federal court under federal statutes, federal laws. State law rights arise from use even within a very small geographic area, like just a restaurant that serves something like that. So it's just choosing which laws you're using, and so whether you're looking at like state laws, like in this case they're in Idaho, so they're like the contract is being interpreted according to Idaho contract
Gotcha.
law.
Okay.
Whereas some of the trademarks claims are federal trademark registration, so that's federal trademark law. Some of them are also based on Idaho trademark law or Idaho consumer protection law. So there's all kinds of levels, and that's what I said.
I see. Okay. Wow. So that's a lot of talking you just did there. I really, really appreciate it. I find this stuff fascinating, I guess.
Me too.
I'm kind of happy I'm not in your world, but but it's good to see those. You seem to really love it, so it's good to see that at least. So yeah, we're gonna have to keep this one up to date. But yeah, I find that this is really helpful and kind of shows that there really are two sides of the story, because everyone online, ourselves included, kind of just showing like bodybuilding.com, but there's this other side. Now, what I have to tell you to the users though is if you look at this development agreement and some of the other affidavits, now this has nothing to do with the court case really, this is just interesting as hell. You're gonna start seeing how much money PhD Fitness and Jim Stoppani were getting paid for each tub. And if you start doing the math, you will see that Stoppani and PhD Fitness, I'm not sure how much of PhD Fitness Stoppani owns, but let's say PhD Fitness seems to have made, over the course of these 3 years, nearly $12 million on this stuff. And we're not talking about cost of goods sold. We're not talking about having to stock inventory. We're talking about them getting nearly, somewhere between like probably 11 and $12 million for doing what he does, producing content and being, the quote unquote celebrity and possibly the developer of these products. So that's a huge amount of money for anyone to make. And Stoppani's obviously earned a lot of that because of his the amount of time that he spent in the industry and becoming the figure that he was and having such a huge following. But I just think once I started doing the multiplication, you're seeing Vitagym, $5 per unit being sold. Basically, it was kind of treated like a power affiliate, but he was getting a cut of every single sale. And this development agreement blows open just about how much was made. So it was mostly like $5 per bottle, except for I think on Pro Gym, which was the gym protein supplement was $4 because protein is typically lower margin. But wow. So Pro Gym and Pre-Gym being the two highest sellers, you know that it's going to land somewhere between $4 and $5 per unit sold. Doing the math, I think it's just fascinating. So we're going to have some links to that, and a lot of money's on the line, and that's why we are where we are. And so I had to throw that in because that's just the crazy part of this.
Yeah.
So other than that, let's say that I am a supplement brand. I'm creating a supplement, and I think it's going to be the next big thing. I have a unique name. What do I do next? Do I contact you and be like, "Hey, Nick, I need a trademark. What would I do next?"
Well, first and foremost, if you're working with somebody else, get a better JDA, get a really good JDA from me or another IP attorney, preferably. I think if you're to the point where you've already got your idea,
Mm-hmm.
A lot of times we get calls like that where it's, "Hey, I've got this mark, I got this product, I'm ready to go. Help me register this mark."
Mm-hmm.
And frankly, it'd be better to get an IP attorney involved earlier.
Really?
At a minimum, do a little research on your own. Frankly, I tell a lot of people, throw it in Google at a minimum, because like we said before, the key here is always use.
Mm-hmm.
And if somebody's already using your mark or something like your mark
Mm-hmm.
for your product, something like your product, then you're not going to be able to stop them, number one. And number two, they're going to be able to stop you. So, I've had situations where somebody came to me and was like, "I'm launching this product in 2 weeks.
Mm-hmm.
Get me a federal registration." And before I even file the application, I look and it's like, somebody already has this registered. You got to brand. I mean, we certainly can't file for this federal trademark registration. And frankly, you need to rethink this. So I think first step is even when you're, spitballing, coming up with cool ideas,
Right.
and names, first of all, make sure you're not using existing trademarks as inspiration too much.
Mm-hmm.
I mean, obviously you can look for ideas, but you don't want to be too close. I mean, trademark infringement doesn't require copying the mark. You can just be close. Have an IP attorney preferably run a search. I mean, most firms, most attorneys will run at least like a basic knockout search at the PTO for a couple $100.
Okay.
And just to be able to tell you, "Hey, look, this is a bad idea."
Right.
You can also, if you're a big supplement company and you're investing a lot of money in it, you can have bigger searches run, worldwide searches run, to make sure that you don't run into this issue in other countries. Because every country has its own trademark
Mm-hmm.
laws, rules, registrations. But there are ways to search all of them.
Is your firm able to do that? Is that something you guys do? Okay, cool.
But yeah, I think the first step is just really to clear it. It's called a clearance search.
Okay.
Or a clearance search. Once you do that, whether or not to file for a registration is not actually as big of a deal. The key then is to start using it. Use is really important. I mean, the U.S. has this unique, fairly unique. You can actually file for a trademark registration in the U.S. without using it.
Mm-hmm.
It's a special application called an intent to use application,
Mm-hmm.
and that kind of like holds your place in line. But you still ultimately have to use it, or you won't be able to get a registration. So, I tell people sometimes if you're really small, you're just starting out, and you've only got, a small amount of money, and it's either file for trademark registration or make my first batch of product and go sell it.
Mm-hmm.
I say make your first batch of product and go sell it. Maybe use some of those profits then to file for your trademark registration.
Right.
Because that day you started using it is the day you've locked in that's your date of first use.
Assuming that you've already kind of cleared that no one else is using
Assuming you
it.
cleared it. Right, exactly. Because if you don't clear it and you go use it, now you might be infringing somebody else's mark, and that's not good.
Now, what if it's in a different market? Like, let's say, PricePlow is trademarked, but I actually forget what I trademarked it for. I probably should know, but either internet or supplements. But what if someone out there in Ohio had a snowplow company? This it was Joe Price's plow company, and he decided to make PricePlow his snowplow company. Would I be able to go after him for that? Completely different industry, different area.
That's easy answer. There is no. You PricePlow, totally different industries. You'd have a pretty hard time.
Okay.
Unless always a caveat, right? I'm a lawyer.
Hang on, I'm sorry. You just broke up that last sentence. Oh no.
I was just going to say, there's always a caveat. I'm a lawyer, but
yeah.
In the case where if your mark was famous, like McDonald's,
right,
then you can stop people from doing it. I mean, I think McDonald's, the famous case is they stopped somebody from selling McBiodiesel, like fuel, totally unrelated to food, restaurant, fast food services, but because their mark's so famous, it's this whole other line of cases it's called dilution. But it's typically your standard company. If it's a totally unrelated industry, there's not much you can do. Again, because it boils down to there's no chance that consumers are going to be confused as to source. Nobody's going to think that you, the supplement computer guy, also run a snowplow business.
Right.
Okay. So in that situation, there really be no risk of confusion, and therefore there's no trademark. Because trademark infringement boils down to the likelihood of confusion.
Gotcha.
That's the test, what it comes down to. On the other hand, if somebody's doing something close, I mean, you've got PricePlow. I haven't looked it up, but you've got PricePlow probably for like online supplements, something along those lines. If somebody made a supplement and called it PricePlow, you probably would have an argument.
Right. Gotcha.
If somebody made an online price comparator for not supplements, and I don't even know what, yard waste,
right?
You might still have an issue because you're both online, you're both doing price comparing. So the closer they get to you, the easier it is for you to stop them. That's kind of the general.
Right. Okay.
And having a federal trademark registration helps on that end. I mean, that it's nationwide notice of your mark, so you don't have to worry about them whether or not they knew about you. It gets you into federal court. So I do think, on the one hand, I said if you've got a little bit of money and you're deciding between your first batch of product and a federal trademark registration, make your product. But I do think eventually you do want to do a federal trademark registration because it gets you out there, it gets you nationwide notice. It gives you something to put in a letter to that person down the line. So those are kind of the thoughts. I mean, and this is all stuff that hopefully if you call a good IP attorney that they're going to tell you about up front. And I mean, I know we don't typically charge for like a first consultation, stuff like that. I mean, this is all just basic info. So.
Yeah, being in Cleveland, Ohio, you're a little cheaper than the New York and LA and Chicago firms, I'm guessing.
Yeah, we can get away with it here.
Awesome. So, nice. So I guess we're gonna close out. I guess am I able to add your domain to the watermark of this image of this video? Like I'm gonna have PricePlow.com down there. Okay. Yeah. And so what is the website?
It's www.rennerotto.com.
RENNEROTTO.
Yep.
Okay, we'll have it in the watermark down there. And so Nick, I really appreciate your time. This has been very informative. That's why I was asking some extra questions because I think it's good to know. A lot of our viewers are supplement creators, and it's stuff they should know. So we'll make a link to your website and everything if they have more questions. And we might need to pull you in if there's any of these, if this case gets moves along to a big point, or if if there's another patent case or some patent stuff that you did want to speak on, we could also talk about that. So, okay. Well, thanks again for your time. Stay on the line. I'm going to close off this video here. And once again, you can check out PricePlow.com and blog.PricePlow.com for the latest news on this. And we will have links to all these agreements that we have and to the blog post in the description of this video. So thank you so much for watching, everyone. And we'll catch you next time.